Welcome to Goodman's. Wonderful to see you. It's a tremendous group given the blustery weather out there. I'm glad we're holding this today and not yesterday, because there were quite a few problems on the road. My name is Richard Corley. I have the good fortune of heading up our outsourcing practice and also of working with Julie Rosenthal and Ira Berg on a number of procurement matters. We also have had the good fortune of working with Rick Wilson, who's somewhere down there at the other end of the table. Rick is now with BDO, and there have been a number of interesting procurement matters and issues that we've dealt with Rick. There are links in the invitation to our profiles, so I'm not going to go over those, and we don't have time. I will note that Julie approaches this subject from a litigation perspective. She's a member of our litigation group. And Rick Wilson comes and has a focus both on fairness and procurement. So he wears a couple of different hats. And Ira looks at things from a real estate and a sort of a land-based perspective. My focus is on the procurement of advanced technology. So we've got a bit of a mixed group up here. We'd like this session to be as interactive as possible, and would encourage you, if you have any questions, just to raise those as we go, because if you have a question, it's likely others do. In order for our online attendees to be able to hear you, though, if you could put up your hand. We have a couple of microphones in the room. One of those will be brought to you, and then you can ask your question on the microphone. So we have a packed agenda this morning, and are going to start off with a brief presentation on the 4 topics that we have there, quite a varied range of topics. And after that, we're going to have an open conversation, and throughout, we're really hoping that this will be really interactive. I'm going to ask Ira to kick off with an update on SIFTA, recent developments there, followed by Julie on the grounds for challenges, more of the litigation side. Rick is then going to talk about fairness and the critically important issues around scoring, and I'm going to wrap up the session by asking some profound questions about the use of tender bids in technology procurements. As you'll hear, I'm not a big fan of that in the technology space. So, anyway, Ira, over to you.
Receptive. Thank you, Richard. Okay. I'm going to be talking about the various procurement requirements that flow out of the Canada Free Trade Agreement, and throughout the presentation I'll just refer to that as SIFTA, as it's commonly known. In July of 2017, SIFTA came into being, and it's an agreement that's now been signed by the federal government, all the provinces, and the 3 territories. And in that agreement, there is a chapter, which is Chapter 5, which talks to government procurement requirements. And just as a note, SIFTA replaced what was the Agreement on Internal Trade. And vis-a-vis procurement, there's a bit of a transition period which is becoming less and less relevant as we move away from July of 2017. But just to note that the procurement requirements of the AIT, as they were, continue to apply vis-a-vis procurements that took place prior to that date, but are continuing forward. Interestingly, the approach of the agreement is to be all-encompassing, generally speaking, vis-a-vis the parties to the agreement. So that's the federal government, the provinces, and the territories themselves, and then a host of entities that are sort of the product of each of those parties. So it is intended to apply basically to every, I'm just going to use the term governmental body throughout Canada. And SIFTA, unlike other trade agreements, uses what's known as a negative list approach, which is really a term which means that unless you're expressly excluded, you're included. Okay, and that's a little different than CETA, which is the European Trade Agreement that Canada is a party to, and certainly the AIT, where only those parties that were specifically, or entities that were specifically listed, were really subject to it. Having said that, the other interesting feature is, although the breadth of the agreement on one hand is very broad, there continues to be a multi-layered facet of the agreement dealing with a host of exceptions, exemptions, exclusions, and limitations on those procurement requirements. So again, while in the first instance, the breadth is quite large, in fact, if you work your way through it, there remains a number of exceptions and exclusions to the application of those procurement requirements. So just to begin, at a high level, the procurement requirements of SIFTA, and the main ones, apply only to what's known as a covered procurement. And a covered procurement, there are some features of that. The first is it has to be for governmental purposes. And currently there is a lack, which I think Julie will talk a bit more on, in terms of jurisprudence or decided cases on SIFTA for sure, and CETA as well, in terms of what does that really mean. There's some case law that has developed in for other trade agreements that use similar terminology, where they've interpreted governmental purposes to be really something of government, something consumed by government, or something provided by government as part of its public mandate. So, in short, although it's a little unclear yet what governmental purposes will prove to mean, we should go into the future knowing that not every activity that a governmental entity carries on is for governmental purposes. The other aspect of covered procurement, and it's phrased in a lot of double negatives, but you're not procuring with a view to commercial sale or resale. So again, a lot of activities that have a commercial component may well not be subject to the covered procurement requirements of SIFTA. I was about to say a threshold requirement, but I'll say a requirement also of covered procurement is that the procurements exceed the thresholds that are set out in SIFTA. And then there's a covered procurement does not include things that are expressly accepted, and we'll get into that in a moment. Here's a very high-level description of the various thresholds, and interestingly, these have been set a little lower than the CETA requirements or thresholds, so that you'll hit the SIFTA thresholds before you'll hit the CETA thresholds. And you can see in some instances, especially for the governments themselves, the thresholds are relatively low. 25,000 for goods, services 100,000, etc. And they ramp up a little bit more, as you'll see, for provincial and federal crown corporations and the like at the bottom, where you're at, roughly $500,000, and then for construction services, multiples of that, roughly $5 million. And these thresholds are going to now, starting in 2018, be adjusted for inflation and so forth every 2 years. As I mentioned, in terms of a covered procurement, some activities and entities are expressly excluded, and that can be found in this Article 504. And there's an A to F description of things that aren't covered. And just as some examples, like the acquisition or rental of land or buildings is not a covered procurement. things which, for the lawyers in the room, interestingly, services provided by lawyers not covered under SIFTA, as well as the retention of expert witnesses. And then there's a host of other types of activities that, again, are excluded from those procurement requirements. Sure.
Oh, sorry, can we get you the microphone?
Oh, okay, you're
On its
right.
way,
Sorry.
on its way,
I
dear.
forgot the protocol.
Microphone police here.
For sure.
Going
No,
back
good
to
for
the
you.
threshold
Yep,
slide,
let me try that. Yep.
is there a reason why services is $500,000? IT services would be covered by that, I'm guessing,
believe
while
that's
construction would be $5 million.
The only thing I can think of is that, it's just in the normal course, which, again, obviously there are exceptions. It's just the critical, mass of a project for construction is, just that much more. But it's not a good answer, right? It's not,
All right.
Right.
Thank you.
Yeah, I don't.
was just curious
It's
to
a
see
good
there was
question.
something.
I don't, offhand. No, I can do a little more digging as to the rationale for the thresholds. But
Thank you.
excellent question.
I
Because in
think
today's world, as we'll get to with Richard, technology procurements are at the fore, and the amounts involved are large and getting larger. So why, such a a lower amount? Excellent question.
I guess if I could speculate, I would
sure.
think it may be because a technology procurement, and particularly a services agreement, could be strategically significant at a level of 500,000 in the way that $5 million doesn't buy you much in the way of a construction
Right.
procurement.
As I said, like the critical
So
mass
from
of
a,
things.
yeah, from
Yeah.
a sort of economy and, from that perspective.
That's a good question. How am I doing for time? Oh, I better pick it up. Okay. Okay, then again, carrying on this theme of exceptions and exclusions, there's an annex attached to the Chapter 5 of SIFTA, which is Annex 520.1. And again, each of the federal government, the provinces, and the territories have or had an opportunity to exclude entities and or activities, again, from the covered procurement requirements. I've just posted here the Ontario version. So you can see there's a very, slim excluded entity. So the legislature is out, but everything else in. And then there's just really two exceptions in terms of activities, which are pretty, especially the second one, pretty tailored on international crossings, which is probably the Detroit Bridge at this point. Then a whole other topic of exceptions and limitations comes in the form of permitted limited tendering. And this is housed in Article 513. And limited tendering is really another way of saying sole sourcing and things, activities there where you do not have to go through an open and competitive procurement, but you can limit it to either, one or few participants. And again, some instances of that where they've introduced, these are sort of special circumstances where no one replied to the, let's say, the RFP or the bid. No bid received was compliant. No, it's sort of a variation on a theme that no suppliers satisfied the conditions. All the tenders were collusive. And the next bullet really deals with that, where in each case you can sole source provided the requirements going forward aren't substantially different than what you had put out to the public. Oop. Oh, yes, we need the thing.
That last one looked like it granted a bit of leeway, actually. Like, I don't know, how big of a loophole is that? like no supplier satisfying the conditions, conforming to the essential requirements. Is that going to control things, do you think, or?
It's possible. I think, again, to me, it's a variation on, that either no one submitted or those that submitted were, weren't compliant. But, well.
So if we're thinking about driving
Mhm.
sustainability excellence,
Mhm.
and typically the tenders don't contain a lot of information around sustainability.
Yep.
So let's say we were going to go for sustainability excellence in whatever category, and most vendors would not be able to meet it. Do you think that would then apply here, or is there something other
Well, I think you run a risk of some bad faith arguments, if I'm hitting your point, about creating a procurement process where essentially none of the bidders can meet the requirements, right? Because that's the test there, right?
Right, but if you
not
had-
one can, but
Right,
none can.
But if you had one that could, then theoretically this would enable you to do that?
Well, they would then win.
Pardon me?
They would then win the
Right. I think not through this.
recourse to
Right.
this. They would just be the successful bidder in that case.
Right, but traditionally there's this whole thing we can't sole source, right? And that's
I agree with you. So that was my point. I think you're in a fragile situation where you're creating a process. Certainly, if you know that only one of your participants can really get through to the other end, because I think effectively the argument would be it is a sole sourcing, right? So you need to be, in some instances, you need to be obviously cognizant of the requirements you're putting forward. In other words, there has to be legitimacy, if I can put it to that requirement, and be vetted to know that that may be the result, but that's of either commercial or some other compelling reason that's a mandatory requirement, so to speak.
So to paraphrase what you're saying,
Sure.
you can't deliberately sole source, but if it works out to be sole source,
I
because
think
I'm the
right,
one-
but again,
Yeah.
right, it's all dependent on the facts, right? Like everything, right?
Thank you.
I'm not trying to dodge it, but I think it's you need to be careful that because you'll see right at the top, right? None of these things, can be used for the purposes of avoiding competition or that is being used in a discriminatory manner. So that's a general principle that needs to be applied to. But you can see there's lots of gray areas, as you're pointing out, right? That's where you go. Oh, okay. I'm just going to, because time is running short, just point out a interesting quasi-new feature in terms of limited tendering, and that's the one right at the top where there's now a permission to essentially sole source for additional deliveries by the original supplier of the goods that weren't included in the original procurement, but now really can only be provided by that supplier for economic or technical reasons and would cause significant inconvenience, etc. So those considerations of economic hardship and inconvenience or substantial duplication of costs are a little novel now, because they traditionally have not been criteria that could be brought in to that type of exception, and now they've recognized that's the case. And I think primarily to recognize the technology frontiers. It's not limited to that, but I think that was the driving impetus to that. Okay, I'm going to skip forward. Okay, so I think my time is short. I apologize to have to cut things. So in short, right, as I said, although in first instance we have clauses that seem to wrap up every activity that the government and government entities throughout Canada take on, in fact, there's a number of exceptions and qualifications in terms of timing, whether it's a covered procurement, the purpose, the thresholds met, and then those hosts of exceptions and exclusions. And then lastly, opportunities for limited tendering. And my experience has been working with SIFTA now for the last couple of years is always having to revert back to the document itself. It's not always intuitive why some things are included, at least on the surface, as to why things are in and why things are out. So it's always, in every instance, a careful consideration and going back to the text to determine in, out, almost in, almost out, etc.
Great, thank you very much, Ira. And maybe Julie, if you'd like to.
All right, so I don't need it.
Oh. True enough.
So my role today is to talk a bit about the different types of challenges that can be brought with respect to procurement processes. And I'm going to open with an editorial comment that that really is not scientific at all, but is impressionistic, and people may well disagree with my impression. And it's this, that what may come across as I speak is a bit of a contradiction. On the one hand, there are seemingly a multitude of rules governing procurements, from the rules that are set out in trade agreements to the rules that the parties themselves set out for the procurement in the RFP document or the call for tenders, to rules that are imposed by the common law. And because there are so many rules, you think, well, there are so many different arguments that could be advanced by what I call the disgruntled bidders. But when you look at the cases, what emerges, at least to me, is that the challenges are hard to win. There are a number of hurdles for the complainants to overcome. There are a number of defenses that are available to the purchaser. And so while it seems like a minefield, my sense is that it is easier to navigate for a purchaser than you might think. The possible exception, and it was touched on by Ira, is in instances where you're dealing with a government entity who is falls under the trade agreements, SIFTA in particular, and before the AIT. And the exception is where you have a government entity who does not conduct an open procurement, but who should. And what we see in the jurisprudence that's come out of the CITT, the Trade Tribunal up in Ottawa, is that they are, I'll call it, stingy with respect to the application of those exceptions that Ira took you through. Now, I should clarify, there are no decisions, no procurement-related decisions under SIFTA as of yet. However, where there were analogous exceptions under the AIT, the tribunal's approach to those exceptions was skeptical, I'll put it that way. So that's the end of my editorial. The rest of my remarks I've organized as follows. They really have two parts, because there are two main types of challenges that can be brought. The first group I call private law challenges, and those can be brought regardless of who the procuring entity is, whether it's government or private sector. And there really are two main types. There are breach of contract claims, and that's typically breach of the Contract A, the Contract A, Contract B paradigm that the Supreme Court has set up. So really the first category is where a disgruntled bidder says that the purchaser failed to follow the rules that it itself set out in the tender documents. The second main type of private law challenge, and you don't see many of them, but it should be borne in mind because it certainly is a possibility, is a claim by a disgruntled bidder for some kind of negligent misrepresentation. So I'll go through those in turn. Then the second overarching category applies only to public sector procurements. And again, there are two subcategories in there. The first type of challenge that can be brought when you're talking about public sector procurements are judicial reviews. And the second type is claims under SIFTA. So turning first to the private law types of challenges, breach of contract comes first. As I mentioned, the basic construct the basic contractual construct that governs procurements. They refer to it as Contract A and Contract B. This comes out of the Supreme Court of Canada decision, now relatively old, in Ron Engineering. And what the courts do, or have done, is they treat the call for tenders or the RFP document really as an offer being extended by the purchaser to potential bidders. An offer to enter into a contract which will then govern the selection process of the successful bidder, the successful proponent. And the courts refer to this first contract as Contract A. So the offer is made by the RFP document, by the call for tenders. It is accepted by bidders, by proponents, when they submit a compliant proposal. The terms of the contract really are what is set out in the RFP document. So it's the purchaser who decides the rules that he or she is going to be governed by. And it effectively will bind the owner, the purchaser, to consider the bids, consider the proposals in accordance with the rules that he or she has set out in the procurement documents. So obviously the first and crucial issue is, was a Contract A created? And the first point that I want to emphasize is that contract cannot possibly be created until bids go in. So when you're in the pre-submission stage, there is no contractual relationship between the purchaser and the bidders. So you'll often hear people talk about the duty of fairness that's owed in the procurement context. That duty, I would say likely, one can never be certain, but likely does not apply until bids go in. There may be other duties owed. We'll come to negligent misrepresentation. But the typical duty of fairness, the duty to consider the bids fairly, doesn't start until a compliant bid is in. So after the bids, the proposals go in, is there a Contract A? Well, it depends on what. You say, well, the courts say it depends on the party's intentions. Yes, question.
Who is determining if the bid is compliant, and is there any duties related to the way it's determined? So somebody submit a bid, they're saying it's not compliant, you're saying then there is no duty.
Yeah, no, that is an excellent question, and the answer is unclear. So I think the case law is clear that if a bid is, they call it substantially or substantively non-compliant, then the purchaser is clearly under no duty to accept it, and in fact may be precluded from accepting the bid depending on the terms of the call for tenders, the RFP document. If the bid is deficient only in a formality, and so the examples I use are the wrong color ink was used to fill out a particular document, or there have been instances where there's a form to fill out that's sort of a summary of the substance of the bid, and a field was left blank, but that information was provided elsewhere in the bid documents. So the courts say, well, that's really a matter of form. To the extent that the bid documents build in a discretion for the purchaser to waive those kinds of defects of form, the purchaser can certainly do that. Is the purchaser required to waive those kinds of formal defects? We didn't find any cases dealing with that. It'd be an interesting argument for a bidder to say, look, this is really silly. You're right, I didn't fill in my middle initial, but you saw it on the next page of the document. You shouldn't disqualify my bid for that reason. Why haven't we seen any cases? It may well be because purchasers don't stand on matters of form like that, because it's not in their interest to disqualify what is a substantially compliant bid, but it remains open to question. But even before you get to those kinds of questions of form, did my bid comply with the requirements of the tender documents, you need to consider, was there even an intention to create a contract A in the first place, right? So we've seen RFP documents that say the submission of bids does not give rise to any contractual duties. There is no intention to create a contract. And the courts will say, well, that is clearly relevant, because what we need to do is to look at the party's intention. This is private law ordering. So in discerning the party's intention as to whether they intended to create a binding relationship, the courts will look at things like, did the bid document set out requirements for a compliant bid? Did it indicate that bids could not be withdrawn? Because courts don't like to see one party bound but not the other. So if the bidder is locked in, the courts are going to want to lock in the purchaser as well. Of course, they'll look to see whether a contract was disclaimed. And they'll also look at things like, was there a detailed scoring matrix set out? But I think the real key is, was there an intention to bind one of the parties? And if there is, the court's going to find a way to bind them both. But as always, it turns on the facts, and it turns on the particular wording of the contract, the particular wording of the procurement document as to whether or not that will be found to have given rise to a contract. So, assuming there was an intention to create a contract, assuming the bid was compliant, then you've got this contract A. And the most common types of breach of contract claims that are brought are for breach of this contract A. And they're typically things like a failure to evaluate the bids in accordance with the rules that are set out in the procurement documents, and that would include a failure to award the contract to the highest bidder. And most, I think possibly most commonly of all, is a failure to treat all the bidders fairly, which really is this sort of broad and encompassing duty that the courts will imply into almost every contract A, if not every contract A. So what flows from a breach of that contract? Well, and this is the highest stakes type of claim that can be brought in a procurement context, because if the disgruntled bidder can establish, first, a failure of the purchaser to follow his or her own rules, to evaluate in accordance with the criteria, etc. And second, if the disgruntled bidder can prove that had the purchaser followed his rules, that bidder would have won the deal, then the bidder gets his expectation damages. He gets the profits he would have made had he won the tender as he should have done. So like I said, it's not easy to establish. There are many cases where the courts say, yeah, there was a breach of the rules, but you wouldn't have won anyway, so sorry, you're out of luck. But it's high stakes.
So damage is not specific performance?
Typically, I've seen an award of damages.
Repeat the question.
Oh, sorry, I'll repeat the question. The question was, thank you, is it damages, not specific performance? Typically, I've seen damages. There are instances where the order made is to quash the contract award and to order a new procurement. But otherwise, typically, I've seen an award of damages. Whether that's because the time has lapsed and it wouldn't be sensible to order specific performance, I couldn't say. Now, the second type of private law claim, and this is much less common. I can't say I've seen much in the way of reported decisions, but it's something to remain alert to, and that is a claim by a bidder for negligent misrepresentation. And the reason it's important is that that kind of claim can be brought even if there is no contract A. The standard elements of the cause of action, you have to prove that a misrepresentation was made, that it was made negligently, that you as the bidder relied on it reasonably to your detriment. Just a hypothetical example, if a bidder said, look, you told me that you would evaluate these bids in accordance with criteria X, Y, and Z. You never intended to do that. Had I known what you would actually use as your criteria, I wouldn't have gone to the trouble of putting in my bid. What's the exposure? I think. I think the exposure really is just the cost of preparing the bid. So it's lower stakes, it's not the full expectation damages, but it has a potentially broader application. Moving on quickly to public law claims. These can only be brought where the procuring entity is a public entity, is some arm of government. As I mentioned, there are two main categories. The first is judicial review. You have your common law judicial review remedies, which can either prohibit or require a public official to take certain action, or which can set aside a government decision. So with respect to procurements, judicial review clearly does not lie for any and all government procurements. In fact, I think it's, I don't know if I'd say a small subset, but it is a subset of government procurements that may be attackable based on judicial review. There are very few reported decisions dealing with this issue. The ones that come out, I think, say this, or at least these are the principles you can draw from them. If the procurement is to be subject to judicial review, it must have what the courts call a sufficiently public character. So the courts ask questions like, is this government actor exercising a power that is, these are the words, central to its administrative mandate given to it by the legislature? Or, by contrast, is it just acting like any other business? So if the procurement is really a manifestation or an example of the government actor who is carrying out a specific statutory or regulatory duty, you've got a shot at bringing a judicial review. Otherwise, you're thrown back on private law remedies, on trying to establish a breach of contract A or trying to establish negligent misrepresentation. And so the example that comes up in one of the cases where the court says, here's an example that would not be subject to judicial review. They said, imagine a federal tribunal, they said, because thinking of themselves, obviously. Imagine a federal tribunal that is procuring cleaning services. Well, that kind of procurement is not an example of the tribunal exercising its public mandate, not subject to judicial review. That's just thrown into private law, rather. Like I said, very few decisions. The ones that are out there either fall into a fairly narrow category that's unusual, or have not been affirmed on appeal. So it's, I would say, a bit of a long shot in terms of a challenge, but it's out there. My last point, as my time is up, is the second main area of public law recourse is claims under SIFTA. I want to state right at the outset is that there are no decisions that we have found made under SIFTA with respect to procurement. So what are the various tribunals going to decide? Who knows? There is some guidance that can be gleaned from decisions under the AIT. The guidance that comes out, I mentioned at the beginning, which is a stingy approach to the exemptions. The one thing I want to mention with respect to SIFTA, the claims are not brought in the courts. The Ontario government, these are for claims against Ontario government entities, has established some kind of tribunal, the nature of which, I have to say, remains vague. A complaint has to be filed with a branch within Supply Chain Ontario. It seems to contemplate an arbitration process. There's very little publicly available information as to what that process is going to look like. It has to be open and transparent and non-discriminatory. Beyond that, your guess is as good as mine. The one thing we do know is that the remedies are limited. For a claim against an Ontario entity under SIFTA, that tribunal has no power to award expectation damages. It has no power to set aside an awarded contract. At most, what you can get is, if the procurement is ongoing, you can get an order requiring the government entity to allow you to participate. and or you can get your costs of preparing your bid and then your legal costs of bringing the claim. But it's, I'll call it, very limited recourse. Last point, if it's a federal government entity, you have a much more muscular dispute resolution process. Similar to when the AIT was in force, you can go to the Canadian International Trade Tribunal, which is, I always thought was a bit of a misnomer. It's not necessarily international at all, but it is a tribunal that runs more or less like a proper court. They can award expectation damages. They can quash awarded contracts, so you have this odd situation where your remedies against a federal government actor are much broader than your remedies against a provincial one.
Great. Thank you very much, Julie. That was a bit of a whirlwind. Now pass the baton and the clicker over to Rick Wilson, who's going to talk about fairness and scoring, a couple of critical topics.
Good morning. First, I'd like to thank Goodman's for inviting me here today to talk to you about the fairness principles and scoring metrics, effective scoring metrics. And my agenda for this morning is I want to give you a little bit of a background and introduction on myself and BDO very, very quickly. I want to talk about fairness principles. You've heard about the duty of fairness. We'll talk about fair, open, and transparent procurement, what it means, and how it can be applied to the different tendering techniques. What is the role of fairness? I'm going to go over very quickly when you can and when would you want to or not want to use a fairness individual. The key focus of it is called effective scoring metrics, and I want to share with you 4 key things that I've learned over the last 24 years that you might want to consider looking at before you release your document, and how you can avoid some of the possible challenges that you would get. And then the last element of my 4th element is how much more you're willing to pay for value. I want to just blow that out a little bit more and explain to you something I've seen people get surprised with very often, and they say, I wish I would have known this before I actually released my document. So just a bit of background. I've been with PPI Consulting was a firm that merged with BDO in 2014. So there was 25 years of history of PPI Consulting. Some people in the room I've done business with before. You might have known us as PPI Consulting. When we looked at transitioning the organization, my partner and I decided, John, that we would look at a large organization that keep the employees moving into the future. Believe it or not, we ran our own procurement to select a firm that would, had a good, I guess, culture, the same culture we had, and would keep our people busy for the future. And BDO was successful, so we've been with BDO since March 14th. And over the last 30 years, we've been involved in 1,400 procurement and fairness assignments. And when you look at a consolidated contract value, meaning the value of the contracts that were let, they're in excess of $35 billion. I've worked at levels, I've worked at federal government, provincial, independent, crowns, you name it. 99% of our clients are public sector. So that's a bit of a background. BDO, which surprises a lot of people, is the 5th largest accounting and assurance company in the world. This gives you some of the metrics. I'm not going to dwell on that too much. BDO Canada is fairly large. It's 125 offices across Canada, and we looked at selecting a firm that we could grow with. We liked the reach of the firm across Canada. It had a lot of locations across Canada. So that's enough on the background. I'd like to talk a little bit about myself. I'm what I called an associate with the Procurement Advisory Services team, and that represents fairness and procurement. I've got 24 years experience of providing this type of service. I've worked at, as you can see, a large, broad sector of public sector entities, and I typically get involved in large, complex procurements. And just to illustrate some of them that I've been involved with, Atomic Energy of Canada outsourced the Canadian government outsourced the operations of the nuclear facilities for the government of Canada for 20 years. That was fairness on that particular initiative. Presto Card, if you're around Toronto and in Ontario and you're doing your Presto Card, we worked way back. Richard and I were talking about that yesterday, back in 2005, 2006. We were procurement on that. Then we did fairness on the high-speed packers, and we've done Ontario Lottery and Gaming, land-based gaming. And these are what you call traditional tendering documents. And these 2 particular ones, the Ontario Lottery and the AECL one, are $3 to $5 billion in contract value. So we've got experience on that. We do have limited experience, which Richard's going to be talking to you about later, in what we call negotiated procurements. I've worked with Richard on the Ontario Lottery digital lottery platform, and I've also worked with Richard in Atlantic Lottery, and I was fairness in both of those roles. And I've actually worked with Ira on the Landon Land-based gaming. So we've worked together before, and I'm involved in the fairness aspect of it. So what I'd like to share with you now is, it's interesting, people say, well, I'm going to do a negotiated procurement, I'm going to do such and such a procurement, I'm going to do whatever you want to call it. Fair, open, and transparent doesn't change. If you're going to go out and you're going to procure something, and you bring in a fairness individual, and they're called fairness commissioners, fairness monitors, whatever you want to say, they're going to operate by these three principles. And you've heard some of this terminology this morning: fair, open, and transparent. Right? These are very general categories of fairness, but everything we do, and Ian Brennan is here as well from BDO today, and he's on the fairness side as well. Ian's vice president of the overall operations for BDO in Canada. What we do is we have to make sure that you can call it, I'm just going to send out something and I want everybody to respond to this, but I'd like an independent attestation of the fairness. Well, the moment you do that, you got to be willing to accept what are the principles this person is going to work with you on. And the first thing is, are you going to run an open procurement? Is everybody going to get treated in the same manner? Okay, sounds very, very generic, but you'll see later on different stages where this applies. Second principle, is everybody get the same information at the same time? And a lot of the times when you're involved in a procurement, you have an incumbent. And an incumbent knows a little bit more than other people. So how are you going to level that setting field with a data room or commercially confidential meetings or something so that everybody feels they all know the same thing going into the procurement? Well, that's what we judge when we do that as well. The third thing, and about the thing I'm going to talk to you a lot about in my 4 areas is how do people get treated when the bids come in? And people hire fairness people at different times. Sometimes they hire us for consensus. Sometimes they hire us for, partway through the process. And what I want to share with you, this is something that if you want to get challenged, and Julie was mentioning this before, and I've gone to one CIT trade tribunal, don't want to go there again. And as Julie said, did you follow the process? Did you have any hidden criteria in your scoring? Did you treat everybody fairly? Da-da-da-da-da-da. I was there. We were successful in defending it. But let me tell you, I could have rang my shirt out about 6 times during the day when you have 5 lawyers going at you, asking you questions all the time. This is, when the bids come in, you've got to be, if they're going to come after you, this is where they're going to come after you, from my experience. Yes?
Sorry, you said you can be brought in even halfway through the process, but in order for proper fairness, don't you have to be there at the beginning, or when you walk in, do you say to yourself, we have to go backwards, or how does that work?
I can offer you a testing to only what I see and witness, and I say, I'm here from then on before I can comment, but if you want me to go back, I'm going to slow you down, and then you might have a few addendums going out the door, and you might not. So I can start here and move forward, or I can do it either way. Typically, people say, oh, I only do fairness for consensus sessions. Well, you'll see some of the traps that and I'm not trying to sell fairness, but you'll see some of the traps that you might get into if you don't do that. Okay? So you can do it either way. I'm only going to attest to what I see. I'm not going to go, how can I attest to it? I don't know. Yeah? So, role of fairness, I'm not going to spend a lot of time on this. So when you take a look at where the value add for fairness, have them look at your document before it goes out. Get rid of some of the ambiguity. Make sure it's clear and concise. There's not a lot of interpretation. If you're going to meet with vendors, have fairness in the room so nobody can accuse you of giving somebody some information that you didn't talk about anybody else to. So whether you're going to have what they call meetings, commercially confidential meetings, demos, presentations, site visits, have fairness around to attest the fact, no, everybody was treated the same way, nobody got an upper hand, and if we did, we negated it and everybody got the same information on the back end. The other aspect is, we want to make sure that if you're, depending what your procurement directive is responsible for, that you're following the procurement directives and the rules that you put out. Again, Julie touched on the fact, did I follow what I said I was going to do? And we're going to make sure you follow what you say you're going to do, because if you don't, what I learned in the CIT tribunal, okay, did you do this? Check. You said you're going to do this, and I think I would have. Like this is what they were just trying to find. Well, if you didn't do what you said you were going to do, what the heck else didn't you do? It was interesting. We look at addenda. We really are of value in assisting. I have procurement and fairness expertise, and I think Ian and I would say that if you have procurement and fairness expertise, you got to be careful with fairness, because you can't write something and rule on what you wrote, but you can advise on what you've seen and give people an interpretation of how it could roll out, and they can then take the pen and work on some of that stuff on their own. We persist in monitor the briefings, and I will write a report only on what I've witnessed, or I can only attest to what I've been involved in. Now, the main thing I want to talk about today, 4 things that I've picked up on, and the first one sounds a little bit, what do you mean you can get gamed? Rick, what are you saying? Well, I was in the private sector for 14 years, 1980 to 94, and I worked for a U.S. company, and I was in charge of government responses for Canada for a company. And they sent me down on these courses on how to game the RFP. And for 14 years, I was on the side of the evil empire. And I was out there looking for loopholes on how I can find something that somebody else might not find out and take advantage of it. Okay? So vendors, and if there's some vendors in the room, I mean, it's out of respect, I have to win what you publish. And if you're going to publish something, so one of the first things is, how do you get gamed? Well, you might think something, the moment you get into rated criteria, you have to take an understanding of, if I give something 2 points out of 100, as an example, and the vendor doesn't give it to me, they lose 2 points, but they save $4 million on their overall bid. So if you want to encourage a bidder to give you something, you don't want to get gamed at the end of the day not getting what you thought you wanted to get, make sure you understand the value of the item that you're rating and giving it a weight associated with it. Because the vendors are going to try to get the lowest cost or the highest score in one way or another. They're going to look at the combination and figure out how they have their spreadsheets going with their competition, and they're taking your criteria and your weights and they're dissecting it. So at the end of the day, you could put a contract saying I want 99% service level, but but that's not I'm going to rate. For example, I'm going to allow you to deviate from that. Well, if you allow me to deviate from it, I might lose 2 points, but I might save $4 million. Second item is, so you might want to mitigate this, understand the cost relative to what you're doing, and if you can't understand that, make it a contractual deliverable or a mandatory requirement where they can't play with you, because they're going to, they're out to win. Everybody's operating by the same rules. This is something that you wouldn't believe how often this happened. This is probably the number one thing that happened. Rick comes in for consensus, BDO's hard as fairness. And I'm saying, sorry, we can't use that criteria. What do you mean? But that's really important to me, Rick. I'm sorry. There's hidden criteria in your scoring grid. Well, what do you mean? Well, you asked a certain question, and how you're scoring it has no relation to how the question's being asked. Well, that's crazy. What do you mean? I'm sorry, that's hidden. You can't use it. So most people write, so how do you mitigate that? So what you want to do is you want to draft the criteria at a high level, but then you want to go before the RFP release to say, how would I score that? And I can guarantee you that 90% of the time you're going to go back and rewrite your question, because you're going to find out your how to score doesn't match your question asked. And I have to sit there and say, geez, you can't score that. You didn't ask for years experience. You asked for this. But I want to score that. But it's not in your question. Most common thing I see. So go out there, understand how you want to score it, modify it based on that. That's really, it's sad when you're fairness because you're like the bad guy, right? You can't use it. What do you mean? I said, sorry, you can't use it. It's hidden. And if you take one of Julie's challenges, if you want to go within criteria, I don't think you're going to be very successful at it. Third thing is this exceeding requirements. I've witnessed this several times. Bids come in. Remember we talked about non-compliant bids? Well, earlier that came up as a question. So, for example, you set a 70% pass-fail threshold, right? Then you have a scoring grid which is 0 to 5. So 4 is 80%, 5 is 100%, 60%. And you say, okay, what I'm going to do that. And then I'm going to say, if you exceed my requirements, so if you meet my requirements, you get a 4, which is 80%. And if you exceed my requirements, you get a 5. And what you find out is at the same time is that a lot of the requirements can't be exceeded. And then all of a sudden your math starts to go down to 65, 60, 62. Nobody passed your 70. Right? Let them use the grid, reward the grid, use the full grid. Because that's what you're trying to do. If you're willing to pay for value, which is the next topic, allow yourself to pay for value. So at the end of the day, to do this, make sure you understand, don't put like if you're running out of 80, don't put a 70% pass fail. If you don't have a lot of exceeds, don't put exceeds. Like just pay attention to that. Because when I'm in the room, if they all fail, they all fail. But Rick, this is crazy. Look at all the time we spent. Sorry, they all failed. And that's just not a great place for me to be or anybody to be. So, be careful about exceeding. By the way, you can have grids that, some can be only, you can have selective grids for exceeding. My last item, which is what I find the biggest surprise that comes from executives, and what do we got for time there? 2 minutes, good, is that, I have a budget, and we're going to go out and procure something, and I got to be careful about my budget. And then you go into an executive meeting, and the executives would say, no disrespect to executives, I don't want this to be a low-cost compliant bid. I want to reward value. I'd like to see price at 20%. Okay, you sure you want to do it? Yeah, okay. So Rick comes in, the bids come in, and what happens is, I'm going to show you this here. So this is an illustration. So for example, 2 bids come in. The first bid scores 75% on the non-pricing things. And their base price is $2 million. The second bid comes in at 85% of the non-pricing, right? Which is 10% higher. So I've got a 10% higher non-price score. It could be demos, it could be technical, it could be whatever, but it's non-price. So the question becomes, is that for this 10%, how much more would you pay for that 10%? Well, depending on the weight you put on price, it varies from $142,000 to $1.3 million on a $2 million comparison. And I'll show you the math on that in a second. So what it means is if you put price at 80-20, like 20% price and 80% non-price, you could pay $1.33 million more for that same 10% value. And you're going to say, hold it, that blows my budget. I can't do that. Well, you said you told them the price was low. They bid it. There's nothing wrong with what they did. So my recommendation is that you take and you look at your trade-offs, and this gives you an idea that you can see for a 60% weight of price versus a 20% weight of price, how much more you'd pay for that 10%. Make sure you understand that before you go in, because I have to hold you to it. And that really is the end of my presentation. And
Question.
okay, sorry. Go ahead.
What's your opinion on including compliance with legal terms and conditions as part of the scoring metrics?
So if I understand the question is that you're going to score the contract?
Yes.
Okay.
Well, you're going to score the technical requirements,
right?
Pricing,
right?
As well as compliance with your published terms and conditions.
So an example being if your public terms and condition reference service levels and they reference other technical things, you have to be careful because you're implying that they don't have to adhere to them. And you, like, let's say, for example, use the example, in my contract it says I want 99.9% service levels, but I'll score that as an item, and I give you 85%, right? And you dock me 2 points because depending how the value, see, when you, and Richard's going to talk about this later, in your negotiated contract, you have to assign values to what you're going to, if someone doesn't give you something, how much of a score off the contract value that is. So unless you value that contract high enough, I'm going to look at it in my vendor hat and say, geez, I can save $4 million. I'll lose 2 points because if I don't give them that 99, you know what I mean? You have to be careful. That's all I'm saying, because the vendor's going to analyze that like crazy. And they should. They're spending a ton of money in responding to these bids.
But when it comes to fairness, one example would be, like, SLAs would be more a technical point of view. But for example, vendor will transfer all IP ownership of whatever they are selling us. And you have vendors that don't have any IP that can respond, and vendors with a ton of IP that will be non-compliant. So this is kind of the example I was looking for regarding to fairness.
So you would have to then determine in advance what value that would be if they didn't give it to you, like how much you would dock them, right? So if the contracts were 20% for argument's sake, okay, how would you actually go around? What are the metrics you'd use to discount that 20% based on the content of the contract?
Great. Right. Yeah, I'll just.
Did you want to add, Ara?
Yeah.
Yeah, I was just.
Yeah, I was going to. Oh, sorry. Go ahead, Ara.
Just having said all that, there's a value, though, to scoring comments and so forth and exceptions to the agreements, because otherwise, when you're now in the evaluation, you're not really comparing apples to apples, right? So there is a tension because it's a difficult exercise, but it's a valuable exercise in order to keep, the level playing field and know when you get a bid, what are you really getting, right? The other feature, just very quickly, is to identify in the terms and conditions those things that might be negotiable and those things that are mandatory and can't be. So, as an example, just to use yours, you could, in theory, say, no fly zones on the assignment of IP. You must agree to that. If you don't, you're not in. Something, or variations on a theme. But there is that. It's a difficult tension to master.
Yeah, I would agree, and I would just add that there are elements that happen to be reflected in the contract that actually go to the heart of the service. Service levels are one which is more than a technical compliance because that really goes to whether, it goes to the substance of what is actually being delivered and committed to. So in that case, you would be looking at that under both the technical compliance with the overall solution, because if they're delivering a solution that isn't going to be working, it hits that, as well as looking for the technical compliance with the, say, risk allocation and other elements of the terms and conditions of the agreement. So I will talk a little bit more about this in a minute, though. So maybe I can get the clicker from you there, Rick. Thank you very much. Great. Now this is sort of one of these really interesting areas, and like Rick, I've been doing this and doing large deals for over 25 years now, and I lost track of the number of deals that we've done, but it's well over 200 billion contract value at this point. And what we found over time, and this is really what has led to today's, what I'm going to talk about now, are the critical differences between technology and construction or services agreements. And we're really looking at procurement to say, if you're procuring for technology, in the same way that we've seen software go from a sort of a monolithic model to sort of a modular approach, and software development go from waterfall to agile techniques, that we need to do the same thing in the procurement space. And in many respects, going back and trying to apply a tender bid type of approach is fitting the proverbial square peg in a round hole, and it just is not a good fit for technology. So the approach that we're discussing here reflects the learning on literally dozens and dozens of projects. I've had the good fortune, as Rick alluded to, of working with him on a number. So we have had fairness and work with fairness, and there's nothing about a negotiated deal that raises any particular difficulties with fairness. Fairness is fairness. I think Rick and Julie both explained that. Something that's interesting is that SIFTA, the most current trade agreement, really reflects, I think, both technology. One of the provisions that IRA pointed to, Section 513, specifically refers to software and interoperability as something that can justify an exception. And SIFTA also includes, for the first time, a recognition of negotiations. So Section 512 recognized that it's sort of a legitimate procurement process to go through a negotiated process as opposed to a tender bid, which I think is just sort of catching the trade agreement up to reality, because we've been doing this for 20 years now. But anyway, so I'm going to briefly go through and discuss the elements of a negotiated RFP process, then draw a bit of contrast with the tender bid, and come back and sort of talk about the advantages and sort of the puts and the takes. So the foundation of the negotiated process is really timely and effective due diligence. And I can't overemphasize this point. There was a question about, what happens if you get to the end of the road and you've got all non-compliant bids. That reflects a profound failure in the due diligence stage of the procurement process, which is, really the setting the foundation and determining whether you've got an RFP that's pointed at your target. If you go to market without doing that and you find your aim is off, you'll spend way more time and way more money later trying to fix that, and sort of CCMs and other things to sort of turn the ship around and get it back on course. The next step is really looking at the design of the RFP, and this is where I would sort of draw the analogy with modular computer programming as opposed to sort of monolithic code. Having something that's modular, lightweight, reusable, and really builds up toward a final contract with a series of building blocks. So it's a way of thinking about the contracting process and thinking about the RFP and how does it plus the response give rise to a contract. Finally, there's how do you put this all together? What are the steps? structured evaluation, looking at the scoring criteria, an agile competitive negotiation, driving right all the way through to a contract. So again, we're sort of looking at trying to maximize efficiency and effectiveness. So why do we bother with this as opposed to a tender bid? I mean, everybody knows how to do a tender bid. They've been there forever. It's sort of the standard. In my experience, when you get into a technology procurement using a tender bid process, while the tender bids work very well for, real estate or a school or a bridge or sort of land-based type large systems, they really don't work well in technology. Technology, you'll see a wide variety of different technologies. You can get different delivery systems. You can have, for software, it's on-prem, it's cloud, it's hybrid. There's a tremendous degree of flexibility, and you want to enable that through the procurement process, which doesn't tend to happen through the tender bid model. So again, in my experience, we find that the tender bid model tends to result in a longer procurement, which in technology is absolutely deadly because technology is moving so quickly. Higher procurement costs, you tend to end up with an out-of-date solution because you're shooting at something that was in the market 3 years ago as opposed to what's there today. And you may also deter, because of the size and the weight of the process, some of the smaller creative companies from coming into the market because they just don't have the resources to be able to go through this process for years, and CCMs and so on. The net result of all of those things is you actually paradoxically end up with a less competitive outcome than if you go with a lighter negotiated model. So this is, and I'm not sort of pointing to this as anything other than a good example of a tender bid process. This was just a deal that I found on the internet. I didn't, identify it, but it's a city waste project, and it's got all the usual approval of funding, get your advisors, get a RFPQ out, you get pre-qualifications, you get the RFP out, 21 CCMs, you get submissions, evaluation, deal approval, and then the actual final negotiations. So what we have here is a total of over 3 years, 170 weeks from the sort of the approval and launch, 59 weeks from the point where we've got the RFP in market, and 10 weeks from the time that the selection has been made until we've actually got a final contract. So that actually, for a standard real property or land-based services, that actually is a pretty good time frame. And I've seen a number of deals where the middle section and just the CCMs and cycling can go for a couple of years. So this actually is a fairly efficient process. So why the concern about this with a technology procurement is that you do have tremendous pressures often to get the solution out into market. You've got technology that's evolving. So 3 years from beginning to end, what you're going to be buying at the end of 3 years is different, or what you need to be buying is different than what's in the market at the start. And also, it doesn't really promote the flexibility to get the really best solution, which is what we're looking for. So now we're going to sort of zoom in on what does the RFP process, a negotiated RFP process, do that's different. It starts out, and I would say at the outset, most of the things that we're doing are not wildly dissimilar from a tender bid process. What we're doing, though, is we're perhaps doing them in a different order, and we're trying to avoid inefficiencies and cycling. So at the outset, the due diligence part is really critical. We use RFIs, RFEIs, RFQs, RFPQs, all the whole alphabet soup of different kickoff mechanisms. We can have meetings, demos, go out there and find out what's in the market. Try and do it efficiently, though, not through a formal sort of RFP and CCM process, which tends to slow down, and you're sort of pushing this bow wave of paper and, documentation and formality. So collect the information. Really critical in the technology space is to say, what are the standards here? What are the things that we want to be focusing on? How do we build in interoperability, expandability, future development paths? One of the key elements of technology is that it doesn't sit in an island. It's not like a school that sits on a piece of land and sort of, doesn't interact. You also want to look at the protocols for how do we adapt this in the future. And then we need to look at the scoring metrics. And the scoring metrics should enable flexibility so we're not driving it towards a particular preordained solution, and leave it open for really creative solutions. Next step is putting together the RFP and building, again, using modular elements. What we try to do is look at this from a standpoint of reducing proponent cost as well as the cost to the procuring entity. One of the things, if you can focus the proponents on giving you the pieces of the puzzle that you need to slot into the existing RFP to create a final agreement, that can help to lighten the burden at their end, accelerate the response time, and also help you to get to a better product in the end. So it is very much a sort of an instrumental process of saying, let's imagine we got the final process taking us through to the contract. From the contract, what elements do we need the proponent to provide, and how can we set them up to provide that efficiently? The actual evaluation and competitive negotiation process, typically we have an opportunity to ask questions. So that sort of does a mini CCM type of process, in that if there are issues with the RFP as it's gone to market, the proponents can identify those. You can issue addenda, update that, try and, again, fine-tune the target of the RFP. You then receive indicative bids, non-binding. We're very specifically and consciously trying to make certain that we do not get into a contract A type of situation, which again is not to avoid fairness, because we are going to be observing fairness, but we want to maintain the flexibility to both parties of going into this with a negotiation and the ability to be able to adjust and pivot with a view to getting the really best solution. What we use is an issues list as part of the proposal. So that's something a proponent will provide. That becomes our tool for structuring a very time-boxed and efficient, hopefully, negotiation. By setting a specific time period, we're, again, reducing costs, reducing the demands on the proponent, and it allows people to go through this process with much more certainty. And the idea is at the end of the time box negotiations, effectively what the proponent has done has enhanced the value of their proposal through the negotiation, and you're then in a position that you can actually sit down and sign the contract. It should be something that can be done. So it's not like the tender bid where you sort of go through this, have an acceptance, then there's sort of a preferred proponent and a sole source negotiation. So pulling this back, stepping back and sort of pulling this together, the most critical advantage is really the accelerated time to contract. So cutting time to contract in a half or down to a third of what you can see in a tender bid process can really add a lot of value both to the solution, to the participation. It really affects the entire process and adds value at all aspects. Among those is it's lowering the cost, so we're lowering procurement costs not only to the entity that's procuring the solution, but also to the proponents that are participating. So you have fewer turns of documents, there's less cycling, and real-time direct engagement as you go through the issues list to get to the final agreement. All of these things will tend to drive to a better more optimized, and a more current solution. One piece in this is as you go through the negotiation, which is right before contract, the solution itself is being sort of updated in real time on the fly, so that you're, at the time that you sign the contract, you're reflecting what is in the market today, not what was in the market at the time that you started the process. Another element here is that unlike a tender bid, which in technology space you often see tends to get driven through the CCMs, the lowest common denominator. There's this sort of tendency where this proponent over here can't do this element, so you can't put that in the RFP, and that proponent over there has something else it can't do, so you end up putting those all together in an RFP, which then doesn't get us to the best solution. Sorry, we do have a question there, if we could get the microphone.
So Richard, just going back to the point you just made there on this delta that will inevitably exist from the time the bid was submitted to the time the deal is about to be signed. Mm-hmm. What is the obligation on the customer? I mean, obviously the person you're negotiating with presumably is the highest rank proponent. He's been evaluated technically on price and in some cases also on legal terms and conditions. But as you move through this process, there's inevitably going to be some change, or there's going to be a delta. Do we need to go back and do sort of a reverse engineer or another analysis to ensure at the end, after that delta, that he's still the highest ranked? Or is the assumption that that delta would exist reasonably with everyone? So any guidance there on where we land, on where we started, and whether or not we're still cool? Yeah.
No, that is an excellent question. And the shorter answer is yes, you do need always to be sort of thinking about your ultimate scoring matrix. If something were to come up in the course of the negotiation, which were to, say, fundamentally take you off in a different direction from the thing that you initially procured, in the most extreme case, you may have to go back and, sort of redo the process, or at least provide the other proponents with an opportunity to come back with a proposal that's responsive to this sort of new vision of the world. The question, though, highlights the critical importance of the due diligence process at the very outset, and trying to make sure as best you can that you're sort of focused on the target, for the range of solutions, and that you've also engineered into your procurement design the sufficient flexibility that you've not sort of hamstrung yourself into a particular vision of a particular solution. So looking at it towards the outcome, if you've done that in the early stage in the design of the RFP, then hopefully you don't end up in the situation that you've described, because all of the offers would have been on the table, would have been contemplated in the scoring, and the adjustments that are resulting from the refinements won't affect the relative rankings. So in our experience, while we always acknowledge the possibility that things may change and you may have to go back and do a sort of a further iteration, that hasn't happened because the work's been done up front, and the gap was sufficiently large that you didn't get into this sort of requirement. Once in a while, though, you will get to the end of the road, and you'll end up with two negotiated deals that are so similar and so close to one another that you may end up doing a BAFO. That's not the usual outcome, but that is again another possibility if you find that after you've done two negotiations that you're really down there, you will then go back and sort of try and push that to the point where you're able to differentiate between the two. So that is a possible outcome at that stage. But again, that's quite rare in my experience. So I think at this point I've probably covered off the points up there on the slide. Maybe we'll throw it open to other questions or have a discussion here amongst the panelists. So are there other questions? Yes, we have a.
Thank you first for insightful comments on a lot of the topics. I'm going to put there are two questions, right? And they're related to technology actually, and in the context especially of the contracts and the advances of technology, and specifically in this realm, I'm thinking about the artificial intelligence. So two questions are, one is that what you have already seen, because on the market, pretty much all consulting firms right now provide some solutions to do that kind of, let's say, automatic scan and so on and so forth, like to kind of, let's say, help purchasers, right, to kind of, let's say, go through the kind of the hurdles of really reading through the contracts, right? So have you seen, and then there's also software providers, and there's more and more on the market that provides the same capabilities. So have you seen good examples and applications of this from your perspective? That's kind of, let's say, looking at the past. And then the second question is that where do you think it's going to take it to the, let's say, the next step in the future, right? How it's going to evolve, and you know, how it can help yourself, let's say, in your profession as well as the buyers.
That's a fascinating question. I think there's, just to make sure that I've captured the question, the first is really about the use of AI in the procurement process, or were you also asking about the procurement of AI? Because there are sort of a whole bunch of different additional issues when you actually go out to purchase an AI system.
Sorry, more so the application, let's say, when it comes to the contract. So not the procuring the AI, if you will, but really the solutions that help right now in AI, how it helps in the process, right? And especially when it comes to the contracts, right? Really the artificial intelligence and really the reading through and scanning the languages, right? And especially the contractual language. So,
yeah, I would say there are a number of very interesting tools that are now on the market. We're working with and piloting and testing a number of them. It's still early days yet, so the ultimate, you know, sort of how this gets played out, but we are certainly looking at making more and more use of automation through the procurement process. The focus right now, I would say, is really we're mostly acting for the procuring entity. Sometimes we're acting on the other side as well. From the procuring entity's perspective, our focus is always going to be on the issues list and the contractual issues which have been identified through the procurement process, and then in the negotiation of those, which is not something that really tends to lend itself to artificial intelligence. That's getting together in the boardroom and stepping through and looking at the balance of risks and costs and negotiating solutions, which tends to be more, thankfully, a human function at this stage. I don't know, Ira.
For now.
At least for now.
I would agree with all that. You know,
Yeah. So,
it's sort of the thing that AI yet, you know, hasn't quite been able to, as far as I know, been able to really do.
No, but it's a great,
effective way.
a great question.
But it may become it. You know.
Yes. So other questions? Yes, Pascal.
I'll stand up here.
Oh.
Just wanted to find out, how do you convince your organization to move away from the traditional RFP tender process to the modular? Because they always say, did you go through the whole process? But of course, it's the time. Comments on that?
Well, it is a process of discussion, discovery, presentations to executives, really looking at examples where this has worked, and being able to point to individuals such as Rick, who have worked with us on fairness and gone through and adjudicated and provided fairness opinions, and also from a legal perspective, trying to avoid the overhangs and the risks associated with a Contract A, Contract B model. So I think when you look at, especially in the context of a technology procurement, the advantages, the flexibility, the decreased time, all of those elements, when you put them all together on the table, they become quite compelling. even if it does represent a little bit of a discomfort zone for those that have done tender bid RFPs all the time. And there's a sort of a continuing dialogue, as we work on these deals. Don't know whether
I was only going to add to that just in terms of a perspective, that not every technique is right for every project. So it's it's sort of trite to say, but I think it's actually quite true here, is that there are certain techniques that are better suited for technology, the ones that Richard mentioned, and others, like the traditional process, could be ideal for all sorts of things. So it's not one or the other. It's what will bring, we'll just use the best value, whatever that may mean to a particular organization in terms of the process. But to be flexible enough to at least have that perspective that not everything is, tender bid, and not everything lends itself to the negotiated process.
Yeah, Paul and then Pascal. Sorry, I'll try and keep track of who's asking questions. Was there anyone else that's sort of in the queue? Yeah, we have Paul is up next, and then Pascal is after that. Was there anyone else that had... Okay, Paul.
I'm going to maybe betray my ignorance here. This is to some extent mediated through some sort of online collaboration mechanism?
Yes, this is done. Certainly, public sector procurements are done through MERCs, and
right,
and that is the mechanism. We are looking at bringing more and more, as the earlier question on AI referred to. We're looking at always trying to bring more automation and technology, try to make more efficient use of technology throughout the process.
Strikes me there's an opportunity here for, as people experience the system, to give their feedback at key points, like identifying those key value drivers or expanding on the issues list, to share learning and maybe iterate and improve this.
Yes, very, very definitely, and that is something that, every time we go through the process, there's always learnings. We're trying to improve the tools and pull that together. And there are a couple of individuals I'll just note at the far end, Rushi and Hart, if you want to identify yourselves, or executives from the Center for Outsourcing Research and Education. And they are, as the name of the organization suggests, very much focused on this type of industry best practices development, and I have the good fortune of working with them on a number of projects and educational programs. So this is being developed sort of through collaboration through groups such as CORE, and I know that Francis is also involved in some work in the same space, focusing on sustainability. So yeah, there's a lot going on here. Yes.
Did you see contract templates evolve since SEFTA and the negotiated RFP disposition came into effect?
So changes to contract
to be more open in the process to negotiation instead of just dropping terms and conditions and...
I'd say, I hate to say yes and no. It depends, because again, as I said, some things lend themselves to it. I think it's emboldened the notion, or the broader acceptance of a negotiated approach, in that it's recognized now, or codified in the very document. Not that it wasn't permitted before, but now it's, seems to be, it's a reflection of a growing acceptance of the practice. Certainly, in terms of documentation and do's and don'ts, because I didn't get into in my thing what it meant to be a covered procurement, right? I sort of was talking about how to be outside of it. But if you're in it, there's a host of things you can, the do's and don'ts of procurement, which have led to a few, revisions and refinements of the RFP and the agreements that flow out of them. But I don't know.
Yeah, I would agree with that. I'd observe that the process that I'm describing here has been evolving in my practice for over the past 20 years, and so no, SIFT and CETA really hasn't impacted what I do personally, but it has, as Ira alluded to, I think, heightened awareness. The other thing that has happened is there's more and more technology in all aspects of business now. So, the internet has changed everything. There's no company now that isn't an internet company. Internet is enabling so many more functions that it is, I think, broadening the scope of procurements to which this type of agile approach is really, adds additional value. So I think there's a combination of heightened awareness, growth of technology, and all of these factors. So I've been getting the hook. I would like to thank all of you very much for joining us this morning and for your questions. I don't know, Sandra, do we have any questions from the internet? Because I know that there were. Okay, because I was going to say if there are questions we hadn't got to, or anyone in the room that would like to send us any questions, we'd be more than pleased to answer those. And we'll be here for a few minutes after this event, so we'd be happy to answer any questions in the next few minutes. And again, thanks very much, and thank you, Ira, Julie, and especially Rick for coming and joining us.